All right, so I'm talking about the new legislation that comes into force in 102 days. All right, so the Act commences on the 12th of March next year. Unfortunately, that's a public holiday. Presents a challenge, but nonetheless, that's when it comes into force. So what I'm talking about here are two things really, and this has been a big challenge in getting information out about this legislation. One is that it deals with advanced planning, and so you're here today at an advanced planning forum, that's not so much a problem. The other is, though, it has significant implications for the process by which medical consent is given to medical treatment by people who aren't able to consent to the treatment themselves, and that's the other element. So it's not just about advanced planning. So when I've gone off to talk to health services and other places, I'm having to keep making the point, it's not just about advanced planning, although that is an element. All right, an important preliminary point to note is this legislation overrides the Medical Treatment Act, which is no longer in force from the 12th of March, and subsumes almost all of the medical treatment provisions in the Guardianship and Administration Act. Importantly, legal documents made under those acts prior to the 12th of March next year remain valid. That's one of the constant queries we'll get at the Office of the Public Advocate about whether someone's enduring power of attorney medical treatment remains valid, and the short answer is if it's valid when it's created, then it remains valid. Okay, so let me talk firstly about advanced care planning under the new legislation, and then I'll look to medical consent. So from the 12th of March, as you can see on that slide, people can make an advanced care directive. They can appoint a medical treatment decision maker, that's the new term for person responsible, and going back further and further, next of kin. And they can appoint a support person, and that's a new role that I'll talk to you a little bit about. So of course there are formal requirements for the making of an advanced care directive, and there'll be forms available from the 12th of March on the health website, you can see there, and on the Office of the Public Advocate website, and in our revamped Take Control book. And you have one of our OPA's new forms on your table there, the flowchart for providing consent. So there are some formal requirements. One of the, for creating an advanced care directive, one of the two witnesses must be a registered medical practitioner. Now, interestingly, in an earlier draft of the bill, there was a requirement that one of the witnesses be either a registered medical practitioner or someone able to take affidavits, like a lawyer. Now, the lawyers have been removed as authorised witnesses of an advanced care directive, and in part I think that's because we are mindful that not only does someone have to have the ability the capacity to know what they're doing in creating the directive, and there's no doubt a lawyer in the Collins Street office could gauge that. But the implication can be, for one of the kinds of advanced care directives that I'll talk to you about, an instructional directive, it is binding. So the concern, I guess, has been that this instrument might be signed now, but it might be put into use in 10 years' time in scenarios that even perhaps the lawyer in the Collins Street office may not foresee how this might be utilised. I think that's part of the thinking why one of the witnesses has to be a registered medical practitioner. There are no specific obligations on the medical practitioner in terms of how they witness it, but the hope is, I imagine, that they would be aware of the types of scenarios in which such a directive might be put into use. Okay, so in terms of, that's one of the witnessing requirements for advanced care directives. For the appointment of a medical treatment decision maker and the appointment of a support person, there's a lower witnessing threshold. So you need two witnesses, one of whom must be either a medical practitioner or able to take affidavits. So there's different witnessing requirements for the reason that I've just gone into. All right, so advanced care directives are legal documents that set out either person's preferences and values, which is a values directive, or binding instructions, which is the instructional directive. It's in relation to the medical treatment of the person, and in the event that the person doesn't have decision-making capacity to consent to or refuse the medical treatment they're offered. So you might have an advanced care directive, but if you've got capacity to make your own medical treatment decision, you make your treatment decision, and that can differ from your directive. The directive comes into play if you don't. Okay, so there are two kinds of directives. The values directive It's a statement of a person's preferences and values and as the basis on which they'd like any medical treatment decisions to be made on their behalf. So this has to be considered by a medical treatment decision maker. And you'll see in a moment, in making any treatment decisions, medical treatment decision maker, we're moving into a new paradigm away from best interests, where a medical treatment decision maker might make a decision based on what they think is in the best interest of the person. We're moving to a situation of what we call substituted judgment, where that decision maker is required to make the decision that the person themselves would likely have made. So how do you know what decision the person themselves would likely have made? A values directive will be very important in that regard. All right, the other kind of advanced care directive is the instructional directive, which is a statement of a person's medical treatment decision that is directed to the patient's health practitioner. It takes effect as if the person who made it has consented to or refused the commencement or continuation of the medical treatment. Now, it's very important, of course, if people take up this option of completing an instructional directive, that they bear in mind the kinds of scenarios in which this might be utilised. For instance, a person might say, I never want any life support. Should I be unable to make my own decisions? And that may sound like an important exercise of a person's preferences. However, as many people in the room would know, there may well be scenarios where another otherwise, for instance, routine operation might require a person to be on life support for 20 minutes and expected to make a full recovery. They've got a binding advance instructional directive saying they don't want this, and they're not able to make a decision themselves, then that's what happens. So in the development of the forms, there's no prescribed form, but in the development of the forms that the Department of Health and Human Services and APA are assisting in this, we're wanting to put flags all over the place on the instructional directive to bring to people's attentions the situations in which they might find an instructional directive being put into play. Important point to note as we go through, wherever there are concerns about the validity of an advanced care directive, or indeed a medical treatment decision maker or a health practitioner wants advice about what they should do in X, Y and Z situations, the Victorian Civil and Administrative Tribunal is the umpire in those situations. Right, let's look at medical treatment decision makers. So a person can appoint a medical treatment decision maker with the authority to make medical treatment decisions on their behalf if they don't have decision-making capacity to make the decisions. A patient's medical treatment decision maker must make the decision, as I say, that they reasonably believe is the one that the patient themselves would have made. This is a paradigm shift away from simply empowering the person to make the decision that they think is the best one in the circumstances, to making the decision that they believe the person themselves would have made. That's why advanced care planning is so important, because it's through that process, and we all know that the process is more important than any document. Through that process we get to understand what the person's wishes are. There's also a new role in the legislation of support persons. So one of the signature developments in the field of human rights, especially when we look at the rights of people with cognitive impairments, it comes under the heading of supported decision making, and the belief that people should play greater roles in the decisions that affect them, and that even where they may have some limitation on their ability to make decisions, they should be supported to make their own decisions. This development is a bit of a nod in the direction of supported decision making, and there's equivalent nods in other legislation in Victoria, particularly in the powers of attorney legislation. Anyway, so this is a new role of support person, and the role, as you can see there, is to support the patient to communicate and give effect to their medical treatment decisions and represent the interests of the patient in respect of the patient's medical treatment, including when they don't have decision-making capacity. So the idea here is a person can appoint a support person, but the decision still rests with the individual, not with the support person. The support person, however, is thereby legally enabled to get, for instance, information that health and privacy legislation would otherwise inhibit them from getting. That's one of the legal implications of this role. So it's a way in which a person can appoint someone else to assist them to get information and to assist them in making a decision. That's all I wanted to look at with the advance planning elements. I now want to turn to the medical consent elements. And they are, of course, related, but there are specific provisions that simply relate to medical consent. Right, a general observation, of course, health practitioners need a patient's consent before providing medical treatment unless they're providing emergency treatment. The new legislation sets out, from the 12th of March, the medical consent process for a patient who does not have decision-making capacity to make the medical treatment decision. All right, so how do we define decision-making capacity? The legislation adopts now a pretty standard definition of capacity that's in place in other countries in the world, particularly draws from the UK's Mental Capacity Act. So a patient has decision-making capacity for medical treatment decision if they're able to do 4 things: understand the information relevant to the decision, retain that information to the extent necessary to make the decision, use or weigh the information as part of a process of making the decision, and communicate their decision in some way. It doesn't have to be by speech, it can also be by gesture or other means. Importantly, adults are presumed to have decision-making capacity unless there's evidence to the contrary. Oftentimes it will be important to allow people to have more time to make a decision if they have, for instance, some degree of cognitive impairment, but the simple fact of having some degree of cognitive impairment doesn't automatically mean they don't have decision-making capacity. The legislation applies to registered health practitioners in those professions you can see listed up there. Now, this is a much broader group of professionals than under previous medical treatment laws. Also broader is the definition of medical treatment, which has 2 parts. So medical treatment is treatment by a health practitioner for one or more of the purposes listed there, and for one of the forms of treatment listed there. So the purposes are around diagnosing, preventing disease, restoring bodily function, improving comfort and quality of life. The form of treatment includes physical or surgical therapy, treatment for mental illness, I'll come to that in a second, treatment with prescription pharmaceuticals. Excuse me. Now that's an important development because our guardianship legislation currently, which is the most important legislation concerning the provision of medical consent for people who aren't able otherwise to consent, currently excludes pharmaceuticals and regular dosage levels from the definition of medical treatment. Pharmaceuticals are now included. So that has significant practice implications for the provision of pharmaceuticals to people who aren't able to consent to their provision, and consent on that person's behalf will now be required. So that's a signature change here. The legislation adopts what you might say is a much more everyday definition of medical treatment. There's also treatment, dental treatment is included in palliative care, and I'll say something about palliative care in a moment. Importantly, special procedures, which a term in the guardianship legislation, still in the guardianship legislation, includes things like sterilisation and abortion for people who aren't able to consent to that. They stay in the guardianship legislation, and consent there has to be provided by the Victorian Civil and Administrative Tribunal, just for those special procedures. All right, emergency treatment. Now, emergency treatment, the term emergency exists in one of the headings in the legislation, but the term itself isn't in the body of the legislation. Instead, there's reference to urgency. So medical treatment or medical research procedure that is necessary as a matter of urgency to save the patient's life, present serious damage to the patient's health, or prevent the patient from suffering or continuing to suffer significant pain or distress, can be provided without consent. So it's an important last phrase there, significant pain or distress. So where treatment comes within that exception, it can be provided without consent. However, if the health practitioner is aware that the patient has refused the treatment in an instructional directive, they mustn't proceed with treatment. Now, I'll say a bit more about the obligations on health practitioners to search for advanced care directives. In short here, if emergency treatment's needed, a health practitioner is not required to search for a directive that's not readily available. The point being, though, if they are aware there is one, then that has to be observed. If a health practitioner is aware that the patient has refused treatment in an instructional directive, there are limited other circumstances where they can refuse to comply, and these cover where circumstances have changed so that they believe the directive is no longer consistent with the preferences and values of the person, or where a delay caused by an application to VCAT would lead to a significant deterioration in the person's condition. In those circumstances, the instructional directive doesn't have to be followed. Now that I know raises questions about what comes within and how do you get advice about whether something comes within those exceptions, and that's something that indeed has to be worked through as the practice implications for this legislation are being considered. All right, obtaining a medical treatment decision. The Act sets out 3 steps for health practitioners to follow when a patient doesn't have decision-making capacity to make their own medical treatment decision, and I'll go through these. So step 1. Is there an advance care directive with an instructional directive? So a health practitioner must make reasonable efforts in the circumstances to find out if the patient has an advance care directive with a relevant instructional directive. What's reasonable in the circumstances? Of course, that's not defined in the legislation. It depends on the situation and on the time frame in question, largely in the person's ability later to if they are able perhaps to regain capacity. Of course, that's something that has to be borne in mind as well. But is there an advanced care directive with a relevant instructional directive? If yes, give effect to that. So if the patient's refused the particular medical treatment in their instructional directive, then the health practitioner withholds or withdraws the treatment. If they've consented to it, then they administer it. So this is, the instructional directive is advance, consent or refusal. If there's not an instructional directive, we go to step 2. Is there a medical treatment decision maker? So there is a hierarchy in the legislation, as there is in the current guardianship legislation. Interestingly, it's a smaller hierarchy now. So at the top is the person's appointed medical treatment decision maker. Next is a guardian appointed by VCAT who has relevant powers to make medical treatment decisions. And then there is the automatic hierarchy of these people: spouse, primary carer, adult child, parent of the patient, adult sibling of the patient. Importantly, there's the qualifying phrase that whoever's at the top of that automatic hierarchy under point 3 has to have a close and continuing relationship with the person. So the distant auntie can't fly in from Darwin and just make a medical treatment decision. The person has to have a close and continuing relationship. And where there are debates about does this person have such a relationship, and are there others who are claiming that they are higher in the hierarchy, VCAT ultimately is the decision-making authority. So if there are more than one in that particular category, for instance, say an adult child of the patient, the eldest of those persons makes the decision. I usually drop in a personal anecdote at this stage, which I apologise, people have heard me say before. I'm the father of identical twins. Who is the older of my identical twins? As a matter of some debate in our house. One was plucked first, but I say they were conceived at the same time. Anyway, that's a question. Would be a question for VCAT, but for the fact I've got an older son. Okay, so is there a medical treatment decision maker? If yes, they make the decision. And bearing in mind, if they make that decision, it is on a substituted judgment basis. It's what the person themselves would likely have wanted, not what I simply think is best. Right, so medical treatment decision maker makes the decision. If there's not a medical treatment decision maker, then we go on. And this is where we divide proposed treatment into 2 categories: significant treatment and routine treatment. So if it's significant treatment, there's no instructional directive, no medical treatment decision maker, then the decision falls to the public advocate or her delegate to make a decision. And this is a variation on a current authorisation process we have, known as the Section 42K process, which is a registration of a document process. It's not so much a decision by the Office of the Public Advocate. So we are moving to an actual decision now in situations where we are talking about significant treatment. The legislation pretty briefly defines significant treatment with a mix, you'll see, of objective and subjective elements. So significant treatment means any medical treatment of a patient that involves any of the following: a significant degree of bodily intrusion, a significant risk to the patient, significant side effects, and significant distress to the patient. That last one, of course, is a very subjective element. So an example here would be someone who has a morbid fear of dentists. Any operation by a dentist might be significant treatment for them, and it might not be significant treatment for Ian over there, I see, an old friend of mine. It might not be significant treatment for him. So there is a subjective element there. So if it is significant treatment, then the decision is made by the public advocate. If it's not, then the health practitioner may provide treatment without consent. And so if it's routine treatment is treatment that's not significant. All right, you have on your table a guideline to what is significant treatment, which goes in rather more depth than those 4 dot points, extends to 20 pages on what is significant treatment, and that's an important guide that's been developed in the lead up to the 12th of March. All right, there are provisions around acting in good faith. A health practitioner who in good faith and without negligence reasonably believes they've complied with the medical consent process set out in the Act is not guilty of an offence or liable for unprofessional or professional misconduct. This is a helpful kind of summary of the steps for health practitioners to take. So in these slides will be publicly available. So you can see there, is there an advanced care directive with a relevant instructional directive? If yes, give effect to it. If not, is there a medical treatment decision maker? If yes, they make the decision. If not, is it significant treatment? If yes, the public advocate makes the decision. If not, the treatment may be administered without consent. Right. The Act also provides for a process for health practitioners where the patient is likely to recover within a reasonable time. If the person is likely to recover in a reasonable time, the treatment can only go ahead if it's consented to in an instructional directive or if the medical treatment decision maker consents, and delay would lead to a significant deterioration in the person's condition. Palliative care. Now this is a very important point. Anyone who purports to refuse palliative care in an instructional directive, that becomes effectively a values directive, so it's only suggestive for a medical treatment decision maker. And indeed there's another provision that enables a health practitioner to go against the desire of a medical treatment decision maker to refuse palliative care. So palliative care can be provided. There's no obligation on health practitioners to provide futile or non-beneficial treatment. It's an important statutory provision that really just brings into force the common law position prior to the 12th of March. And there is a consent process for the provision of medical research. There's a similar procedural authorisation process where medical research is proposed to someone who's not able to consent to it, as currently exists under the guardianship legislation known as Section 42T process. Importantly with this legislation, we're getting rid of a bizarre distinction in Victoria between, it's a bizarre distinction that most lawyers can't even tell you what the distinction is, but between withholding consent to treatment and refusing treatment. We're getting rid of that distinction now, which is good, and the way we're doing it is essentially by empowering all medical treatment decision makers to refuse treatment on behalf of a person. Now you'll understand there are ethical issues involved that perhaps distinguish a situation where I appoint someone, I appoint Joe to be my medical treatment decision maker. I can do that knowing that I'm empowering Joe to make decisions. It might be different though if I'm not authorising someone, but someone has that role simply on a statutory hierarchy. We're empowering both to refuse treatment on my behalf. There's an important safeguard there that largely we think will apply for people with lifelong and significant cognitive impairments, whereby if a health practitioner is aware that a person's medical treatment decision maker is refusing treatment and they, the health practitioner, reasonably believe the preferences and values of the patient aren't known or are unable to be known by the medical treatment decision maker, they must tell the Office of the Public Advocate, which can then decide whether to make a guardianship application in those situations. All right, you'll see there the websites for further information. And just to reiterate on the obligations of health practitioners, there are broad settings where urgent treatment can be given without consent, including to prevent significant pain and distress. As I said before, health practitioners can't treat if they know there's been a refusal of treatment in an instructional directive, but the obligation to search is only what is reasonable in the circumstances. Again, the general obligation to find a medical treatment decision maker also is what's reasonable in the circumstances. Importantly, in terms of finding an instructional directive, of course, there is no compulsory register at the moment. We'll be hearing later on about the My Health Record facility, and there will be the possibility of people uploading their record onto My Health Record, but of course registration is not compulsory, and so you have the question, the operational question of, I complete an instructional directive, 5 years' time, put it in my filing cabinet, in 5 years' time I'm presented to emergency. How does anyone know I've got an instructional directive? That's an operational challenge. That will, in short, what we're saying to people is if you have an instructional directive, you really need someone to know about this other than in the context of a current relationship with a health practitioner. And that's all I wanted to say at this stage. So you can see those websites. There are a range of materials on your table, and we are looking forward to hearing your thoughts as we go through the day about the practice implications of all of these significant changes. Thanks for your attention.